स्टार्ट करेंगे। ओके चलिए, या गुड इवनिंग किसले। ओके चलिए, तो क्या पेपर शुरू करते हैं। लेट एवरीवन कम। मैं ऐसा करता हूँ, किसी एक को मैं यहाँ बना देता हूँ एडमिन, ताकि वो इंडिविजुअल लोगों को इन करता रहे, ठीक है। और फिर हम लोग पेपर स्टार्ट करते हैं इंडिविजुअली। ओके, किसला विल डू इट। आई एम मेकिंग किसला द को होस्ट, है ना। आप इन करते रहिए सबको, ठीक है। और मैं ये तब तक स्क्रीन प्रोजेक्ट करता हूँ इस पे। ओके चलिए। Paper was quite nice, huh? People are quite happy. I am also very happy. You can say from my face, right? I'm very happy. Paper काफी easy था actually में, right? That was remarkable actually. Okay. सबको स्क्रीन दिख रहा है? Everyone can see this screen, right? Okay. चलिए, तो स्टार्ट करते हैं कि ये पेपर कैसे लिखा जा सकता था, how it could have been written. क्वेश्चंस बाद में करते हैं चैतन्य, ठीक है। और चलिए ठीक है, एक क्वेश्चन मैं पूछ लेता हूँ, क्या आप कहना चाह रहे हैं। यस चैतन्य, गो अहेड, क्या कहना चाह रहे हैं, टेल मी। ठीक है, एक दो मिनट और वेट कर लेते हैं, लेट एवरीवन कम, ठीक है। बड़ा अच्छा पेपर मुझे लग रहा है, आई एम क्वाइट हैप्पी लुकिंग एट द पेपर्स। तो प्रयास करेंगे कि एटलीस्ट 1 घंटे में एक पेपर खत्म करें, राइट। क्या लिखना चाहिए था, राइट। देखिए, मोटे तौर पे मुझे जो लगा इस पेपर के बारे में, राइट, वो ये कि जो पेपर 1 है, ठीक है, काफी डायरेक्ट और काफी इजी क्वेश्चंस पूछे गए थे, राइट। पेपर 2 थोड़ा सा कॉम्प्लिकेटेड आप कह सकते हैं, डायरेक्ट क्वेश्चंस उसमें भी थे, लेकिन थोड़ा सा जो है ना, कुछ कुछ टॉपिक जो है ना बिल्कुल यूनिक टाइप से उन्होंने दे दिए थे, जिसका कि कोई लेना देना नहीं है, ठीक है। तो ये एक थोड़ा प्रॉब्लम हुआ पेपर 2 में, इसमें कोई डाउट नहीं है, राइट। लेकिन ओवरऑल जो है ना, पेपर वाज गुड, ठीक है, पेपर वाज गुड। अब बढ़ते हैं, स्टार्ट करते हैं। ओके चलिए, तो लेट अस स्टार्ट विद इट। फर्स्ट इज द फंडामेंटल राइट मे बी सेड टू कॉन्स्टिट्यूशनलाइज सोशल वैल्यूज और एग्जिस्टिंग सोसाइटीज, ठीक है ना। देखिए कितना अच्छा सा सवाल है, राइट, कितना फिलोसफिकल टाइप से सवाल है, राइट। देखिए, जब भी मैं फंडामेंटल राइट है ना पढ़ाने के स्टार्ट का प्रयास करता हूँ, या जब भी whenever I start with the concept of fundamental right, I always tell you to understand the philosophy behind it, right. So primarily there are three philosophies if you think about it, right. The first philosophy is that it idealizes what as a society you want to achieve, right. So that is the first philosophy of having a fundamental right. It idealizes that what kind of society you want to be, right. Is first philosophy, right, that itself is what the social values. When we are talking about that what kind of society we want, so essentially we are talking about the social values we want to incorporate in our society. Getting my point, right? Now if that is the question, right, then how to approach this particular question, right? So you have to first talk about philosophically why fundamental right, okay. And one of the aim of the fundamental right is to build a welfare state, right. Now then you write to have a welfare state, there are certain aspect, or there are certain principles that you might want to protect in that particular welfare state, right. And those principles are enumerated in the fundamental right, right. So you write in the introduction part, and then you go on and start writing the principles and the fundamental right which tries to protect, right. Principles of equality, right, the fundamental right. Principle of non-arbitrariness, or you can say principle of equality, what we say, this non-discrimination, in the sense untouchability should not be there. Principle of secularism, right. So what you have to do, that you have to clearly pinpoint, okay, these are the principles, okay, and these are the fundamental right connected to those principles. Getting my point, right? And then you could have ended it with some illustration, that is your recent case law Sabrimala, you could have cited it, right. Sabrimala is a right of privacy case that you should have cited, right. Individual freedom is also one of those principles, and right to privacy affirms that particular judgment. Getting my point, right? So there is a very interesting question, and very nicely it could have been written, paragraph by paragraph, giving proper headings. Getting my point, right? So quite simple that is. Then if you come to question number 1B, that is your public interest litigation in India is judge led. Now there was a similar question that asked in our test paper, that PIL connects court to people to government, right? So this was the similar question that I have asked in the test series, right? Now what should be the structure? Now whenever there is any question with regard to PIL, in the test series discussions, I might have told you, those who are of test series student, right, that whenever there is any question of PIL, first you have to start that PIL as essentially an Article 32 application, and it have been evolved by creative interpretation of the Supreme Court, right? It have been evolved by the creative interpretation of the Supreme Court. Getting my point, right? So that is a very interesting thing that you should have written here, right? Very creative interpretation of the Supreme Court. Because without creative interpretation of the Supreme Court, this PIL could not have been come about with, right? Then you could have mentioned, the name of the judges in the beginning, right? Introduction part. And then you have to write that, a separate heading. It is judge-led, write a heading, it is a judge-led, and then you start. How it is judge-led. See, in PIL, basically, there are essentially three things. First, even if you have not exhausted any remedy, still the court might take that particular application, right? So it means it is up to the judge to decide that whether you have exhausted all your remedy or not, right? Second, procedural part, that even if the procedural part is not fulfilled, then also the judge could admit an application under Article 32, right? Now, with regard to procedural part, you could have written that how even an application from a convict, right, or even an application from a poor person have been, included by the court as it is a writ petition under Article 32, right? So that actually leads to it is judge-led or judge-induced, right? In the case of judge-induced, you could have made a separate paragraph and you could have written that the judge-induced, meaning the judge sometimes suo moto makes a particular application as NPA. The best example would be that recently under Article 32, if you will remember in UP, when the government started to publish the names and the photos of the convict in the streets of UP, the Allahabad High Court took a cognizance of it and stopped it, right? So what you have to write here that how it is judge-led with regard to procedure, with regard to requirement of 32 fulfilled or not, right? And judge-induced, it means que suo moto cognizance. And then you could have given some examples with regard to that. Okay, so very nicely, introduction part, PIL, how it is a creative interpretation, then how it is judge-led and judge-induced, and then the examples of that. Right, so very nicely you could have written, these three parts in this 10 mark, right? So very easily you could have got 5, 7, 8 numbers, not a big deal. Similarly, 1C, right to education is a base for fundamental right and the human right. If you remember, there is a specific question in our topic in our UPSC, that is your interconnection between fundamental right DPSP. Okay, so this interconnection question that is here, right? Because right to education is a part and parcel of your DPSP, and it is now also has become a fundamental right. So what you have to do that you have to first identify the introduction part that how DPSP and fundamental right interconnected, and then you have to specifically write that right to education initially a DPSP, right, but have been included under the fundamental right, and right to education leads to, right? Then you could have pointedly written it leads to more awareness of your social being. It means Article 14, or you can say equality can be assessed. Okay, equality can be done. It leads to more awareness with regard to your surrounding, your religious identity. That leads to more fulfillment of fundamental right related to religion. Right. So what you have to do that you have to connect how education leads to a person realizing each and every fundamental right, and you could have done it by example. Getting my point? Understood, right? So this question was more philosophical in the sense that the education is the primary thing which a citizen must have so that he may realize all the fundamental right in his actual life. Getting my point, right? So you could have given examples, right? Like a poor citizen or an uneducated citizen might not be even aware of its implication, in the sense that might not be aware of the fundamental right. Let know it's fulfilled. Getting my point, right? And then you could have cited that realizing this growing importance, right to education was made into fundamental right? So that was the introduction and little bit body part. Then you have to talk about right to education with regard to children. Okay, then 6 to 14 years and RTE Act. Basically, here you have to mention the RTE Act and some of the provision of the RTE Act, right? How it emphasizes that the government will necessarily allow 6 to 14 years of a student to study freely. Okay, and they will be provided education in their local languages, vernacular languages up to there. Most of the time, mother tongue should be used. Okay, so those are the RTA stuff, right? Or all the basic provision of RT, right? That could have been cited here, right? Very nicely. Getting my point, right? So the introduction part, DPSP and fundamental right interrelationship, right? Every year there is a question. Remember this particular point. Every year this interaction part question all will come. Like last year there was a question, basic structure and preamble. Right? So this habit of connecting two or more topics, right? So that is a very unique thing with the UPSC. Okay, so please keep that in mind, right? So this is something you should must remember. Now let us come to 1D. I think Vikas is here. He is also one of the student of the series, I think, right? Yes, Vikas. Okay. Yes. So 1D, explain the relationship between president and the council of minister. Is the president bound to accept the advice? Now see, it is literally the topic of the syllabus, the relationship between council of minister and president. I mean, if you are a framing question, you cannot frame more easier question than this. Think about it. If this is the topic, you are simply given, okay, write about this topic. Right? So there cannot be even easier question than this. Very easy, right? How will you approach it? So we will talk about we adopted a parliamentary system and it is based on the British democracy. President with regard to crown and council of minister, British parliamentary system, right? And then its constitutional manifestation, you will write, these are the articles 74 onwards, right? And then you will come, because this is a 10-marker question, because these two will be in 2 paragraphs, now you only have 2 more paragraphs to write. Then you will direct away come with when the advice is binding and when the advice is not binding. Getting my point, right? There are multiple cases, right? One of the very famous case, UN Rao versus Indira Gandhi, right? So where when we say advice of council of minister, the council of minister must enjoy the confidence of the house. So if the council of minister has lost the confidence of that house, then the advice is not binding, right? So when we say council of minister, it means ki the council of minister which enjoys the confidence of the house. Getting my point, right? Similarly, you write that there are certain provisions whereby the council of minister advice is irrelevant, like appointment of new prime minister, dissolution of Lok Sabha, right? So in those cases, the advice of the council of minister is irrelevant. Getting my point, right? So you have to clearly pinpoint, okay, these are the advice where they are binding, these are the advice where these are not binding, along with the cases, right? So this is a very direct, to the point question. There is no problem with that. I hopefully all of you have written this particular question, right? Very nicely. Okay, now with regard to question number 1E, that is your delegative power of legislation, right? So what is that delegative power of legislation, right? If you look at the word delegative power, right? So this is again the most easiest question that you could have written, right? The delegative power, delegation of legislative power has neither been permitted nor prohibited under the Indian Constitution. In Ray Delhi case, right? Very famous. Now, if you will look at the constitutionality, then one thing you will write that it is not have not been prohibited. You will support the argument. Henry VIII clause in the Constitution, the president have power to modify the Constitution to suit the certain situations, right? And then you will specifically write a very important delegatus non-protest delegated, right? There someone who have been delegated cannot further delegate a particular thing, right? So delegatus non-protest delegated, and then you will write how in Ray Delhi case the Supreme Court did not took the extreme view of USA and neither took a much liberal view of UK, but said that we had in between somewhere. It means in certain scenario we will allow the delegation, and certain scenario we will not allow the delegation, right? And then you will write discuss the constitutionality. Then in the case of constitutionality, you will write that delegation is allowed, but delegation is allowed using policy and guideline theory. The essential function cannot be delegated, but if the delegation occurs, then that must be accompanied by some policy and guideline. It means that delegation cannot be arbitrary, or delegation cannot be up to extreme level. Thus these 2 points, okay? And then you write certain cases that in, like for an example, if there is a law which says that parliament will or the executive will provide for taxation, right, for the purpose of this. Now this one line for the purpose of maintenance of public order. Now this is sufficient guideline for this particular time. So if you are providing for a delegation and not providing guideline, that would be held unconstitutional, right? So that is the substantive constitutionality and unconstitutionality. Sometimes unconstitutionality may also arise of procedural part, right? Like with regard to delegation, it has been provided if you delegate something, right? If you delegate something, then that delegation, if is provided, would be delegated after following some procedure, right? So that procedural aspect is important. Like for example, with regard to publication, right? If the delegated legislation is required to be published in local language, then that becomes a very, very mandatory thing to do, right? So this part, discuss the constitutionality, you will talk about substantive constitutionality and you will talk about procedural constitutionality. Just one line. These are the first point of substantive, these are the first point of procedural constitutionality. Okay, very easy question actually. This is a very remarkable question actually. समझ में आ रही बात सबको ये? This point is ever clear to everyone? Yes? अस्थवी लिखा तुमने ये बात? Have you written this? Where is he? Is gone. Good student. He will definitely score good marks this time. Okay, chaliye. So let us come to now 2A. Very interesting questions. Everyone is able to hear me very nice and fine. Yeah, I'm recording it. Hopefully, this recording will be shared. Okay, I'm recording it. If the recording is very good, it will be shared with you all. Okay, but I don't know. Sometimes recording is not very good, right? So I will advise you to remain here and read. Okay. Chali. So let us come to the next. Another very interesting thing, that is your pluralism, pluralism, and this Indian secularism. Right? Each year there is a question on Indian secularism, right? It's one way or another. See, whenever there is a question with regard to Indian secularism, right? Anytime, what I always advise is that leave what is written. You make a ready-made answer that this is what I am going to write. Okay, and to talk about what are the different meaning of secularism, right? Which meaning the Supreme Court of India adopted by giving a specific heading, right? The court's interpretation, right? And then cases, and in that cases, the judgments, the individual sentences given by the court, that what they understand by this, the concept of secularism, okay, right? And then finally writing some jurist opinion or sort of a way forward that what could be done with regard to secularism. So this particular format is aptly suited for this question as well, right? So whenever there is a philosophical question of secularism, you need not to fetter over the statement what is written. They might write any type of a statement taking from any aspect of this secularism, right? But you follow your predetermined, right, and just little bit mold it according to the statement. Like for an example, a good and efficacious pathway, God realization, right? So you write little bit, this is basically a communism, communist part of secularism, a communist perspective of secularism. Okay, right? So even though you don't know this specific point, it is a communist perspective of secularism, right? Need not to fetter about it. Simply write these pre-made structure. Any philosophical aspect automatically covered in that. Right? So if you remember the notes, right? You remember the notes that I've given you, right? That particular note also, I mean that foundation course note, right? In that course note, I have specifically given you certain lines with regard to secularism, right? That is more than sufficient. Let me show you notes as we are here only. You can, I can actually show you the notes because I have some of them with on my laptop. So if you look at those notes, right, very, exactly, very nicely, it can, sum up the blocks of secularism. Okay, these are the basics of secularism, and nothing more is required from that. Okay, like one example. Let me give you an example. Actually, give me a minute. I am opening it. So let me share with you these notes. Yeah. So all of you can see these notes, right? Yes. All of you can hopefully see these notes, right? So if you look at these notes, right? So I have very nicely here provided, preamble part. See this, whether it is a part of constitution or there is a separation or secularism part. Let me go to the secularism aspect of it. Equality, preamble, Indian territories. Secularism a part of constitution. Give me a minute. Sorry, it will be in the beginning itself. Yeah. Yeah, see here. It is a key to legislative history of preamble. I have to keep making everyone. Yes. Justice, equality, secular. Yeah, see. Secular needs to be redefined. Now, this secular, right? The word secular means do not support any state. Secularism under Indian constitution. See, there are three principles. This is the three principles that I was talking about. No concern theory, no link theory, and equal respect theory. Right? So there are three theory with regard to secularism, right? More than that is not applicable here. Okay, no need. Similarly, you have to talk about this secularism, that how in S.R. Bomai the court actually talked about secularism, right? So that is what actually I was talking about. That you have to simply clearly bleep. Is it not visible to all of you? Bukhari is saying that is not visible to you. All of you else, it is visible. This whole PDF is visible to all of you. Yes. Yes, it is visible. Okay, it is visible. Right. So how nicely this whole statement, in your notes. Those who are foundation must be having this notes, right? This is more than sufficient. Right? This is more than sufficient. Getting my point, right? So ultimately, when we talk about secularism, right? Then one thing that was also there sometime in the question is secularism, not although not very much provided before 14th second amendment, but it was implied under the constitution before the such amendment. Right, so that part also sometime they ask. Right, so this whole content is more than sufficient to answer that particular question. Right, now this is a very important part. Always remember this, right? Secularism under the Indian constitution. That is what actually I was talking about. That you write down. Any philosophical question is there that this definitely has to be written. Getting my point or not? Understood? Okay, right? So quite as simple as that. Okay, now let us come to the next question, 2B. Now this, if you look at the question number 2B, right, it talks about, discuss the process of the appointment of the judges of the Supreme Court, okay, and the High Courts, and transfer of judges of the High Court in light of the decision of the Supreme Court of India, right? Judges transfer case 1, 2, 3, right? And then you have to talk about the constitutional provision. Right now, here you have a lot of content to write. I am very sure that you all must be knowing what to write, right? But the question is that how to write it, right? So in what respect, right, or in what you have to mold it, right? So how to write it? Let me tell you. First, you have to talk about initially, right? We discuss the appointment, right? So you have to talk about that the constitution initially intended the executive and the legislature, the executive and the judiciary with interdepending each other will appoint the judges of the Supreme Court, and then you wrote the provision that in the consultation with the chief justice. Then you write, with the passing time, this word was creatively interpreted by the Supreme Court, and consultation was defined as, so first judge's case, collegium system comes. Second judge's case, it was increased to the third, and then the third judge's case, they tell that it is compulsory, right? That word consultation means basically concurrence, okay, right? And then you go on and write that how recently the Supreme Court has struck down a constitutional amendment for the appointment of judges, that is NJAC, right? So you write about NJAC, Advocate on Record Association versus Union of India. There is a very famous case, right, where it was struck down, right? And then you write, recently the collegium system was restored, and as per the collegium system, this happened. Getting my point, right? So the committee recommends to the High Court recommends to the Supreme Court collegium, and Supreme Court finally recommends to the government, and the government lays down certain administrative mechanism vis-a-vis appointment. Right? Recently, you could have mentioned, Justice, if you remember, Justice N.V. Ramanna recently gave a statement, right? I think 3 days before. It is a myth to say that the judiciary appointed judges appoint new judges. Do you remember that statement recently Justice Ramanna said, right? Because once that particular recommendation goes to the, to the executive, there's a IB report, there's a report, with regard to vigilance, right? And then ultimately, it goes through the law secretary, etc., etc., and finally the president writes the, gives the appointment. Okay, so that should have been cited, that even though it seems like executive is not a part of the decision-making process, but they are very much part of the decision-making process. Getting my point, right? So very nicely you have covered the recent happening also. You have covered the historical aspect also. You have covered the substantial aspect, right? So each aspect should have been covered very nicely. समझ में आ रही बात ये सबको? Yes. Okay. आगे बढ़ते हैं, because और ये individually, जो क्लासेज होंगी, राइट, जैसे कल से जो क्लासेज है, राइट, वहां भी मैं डिस्कस करूंगा इसमें इंडिविजुअली, नॉट टू वरी दोज हु आर ज्वाइनिंग अस टुमारो. ओके, चलिए तो 2B देखते हैं. 2C, कि डिस्कस द पर्पस फंक्शन ऑफ आर्टिकल 256 to 57 of the Constitution of India. Right? Now, how interesting this question is, right? Because when I teach, I always tell you to understand what is the rationale behind it, why this provision have been given. Right. So this test series also I gave you a very interesting question. What are the options available to the union if the state refuses to follow the order of union? This was a question, one of the question of the test series, right? Now, what was the intention of it, right? So when the states refuses to follow the order of union, there are two type of options available with the union, right? The first option is the coercive one. If they can pass a direction under 256, and if the direction is not complied, that is a ground for emergency. Then there is a non-coercive thing that you can, call a meeting of interstate council, right? You can ask the state to please follow it, right? Second coercive action that the parliament have, that the parliament can amend the constitution and take that particular subject in which the state have the jurisdiction to the concurrent list or to the union list, thereby simply deleting the legislative, right? So that is the combined reading of 256 to 257, right? Now, should these provisions be restructured? This is a question of federalism, because you write that this strikes the very core of federalism. right? This strikes as a very core of federalism. Getting my point? Now, if you remember, I have given, let me check, question number, I think test number 2 of any student, there I have specifically, given that what are the options available to the student. Asthavi itself, I can check here, but she might not have written the questions, right? So let me check another answer where I have specifically given this particular question. Yeah, Riddhis, yeah, this is good, right? So this is where I might have given one of the question, right? Power and Function of Public Service Commission, PRI. It will be very tough to, like, this is the ground of a question that was asked. Okay, I will show you the question from the question article and the question itself later on, right? So this question is about the federalism. Right? This question is about federalism, that what the option the union has, right? If the state define. Right? So this was the exact question, obviously not exact question, but in a similar fashion I have asked. Getting my point? Understood, right? So very interesting part actually, right? Very interesting part. Okay, so what you have to do, understood in this particular question? Any problem at all? समझ में आया कैसे लिखना है इस क्वेश्चन को? Yes, no, yes. What is the option available? Okay, चलिए तो आगे बढ़ते हैं. Okay, now let us come to the next important question, that is your 3A, free and fair election, right? Now what is a free and fair election? That is a very interesting thing to understand, that what is a free and fair election, because when you talk about free and fair election, right? So this is a question that required a very philosophical sense, that okay, these should be written, very philosophical sense, right? Like for an example, you could have written here, if you read the question, if free and fair election is a basic structure of our constitution, and it is the heartbeat of democracy, right? And this is the heartbeat of democracy, full stop. But widespread corruption and increasing criminalization in the election process have made our democracy weak. Okay, have made our democracy weak. Discuss the various efforts undertaken by the Election Commission to ensure free and fair election. Right? Now, how beautiful this question is, right? Because it not only asks you that what are the challenges election commissions are facing and how the election commission have handled that particular challenge, right? But it also want you to give that what specifically election commission has done it with regard to those challenges, right? Now it also talks about philosophically that how constitution is at threat because of elections. So I've told you that whenever you write a question with regard to election, always and always write that elections are nothing but it is a substitute of revolution. Any government which comes to power, right, then it is adjudged only through elections, right? So if the elections are not there, ultimately it will lead to revolution of that particular country. Then you go on and write very nicely philosophically that every constitutional democracy have certain organs to protect the ideals of that democracy, and one of the founding ideals are elections. Election commission in India is no different. Okay, so very philosophically you have introduced, right, purpose of election, right? You have introduced that why preserving election is important, and then in the body part you start with the concept of constitutional provisions, and then you write that how the election commission in India functions, right? Right, the granular detail with regard to it, and then you write the problems faced by the election commission, right? The out criminalization of politics is one of them, right? Then you talk about how election financing is one of the problems that is election commission is facing, right? Then you write down how this hate speech is also one of the problems that election commission is facing, right? So you write down these separate headings, and very generically that how it weakens democracy. Okay, and then you write down the efforts taken by the election commission specifically, and then write election financing laws are there in place. You could have cited recent electoral bond in this, right? Then you write that how election commission, through the judgment of the Supreme Court, ADR judgment, where the court have said that you have to publish the criminal antecedent of all the candidates, and it have been made widely applicable, right? Similarly, launch of an app by the by the election commission, where the election commission has talked about that whenever you find any criminalization, you simply record it and send it to us, and we will take action with regard to it, right? So you write the practical examples whereby the election commission has actually done in order to ensure free and fair election. Getting my point? And then you write certain suggestions that if you want the election commission needs to be strengthened, etc., etc. Getting my point, right? So what you have done, that you have philosophically talked about the philosophical aspect, you have covered. Then you have covered the problem that has occurred in in the election process. Then you have covered the power or the solution that the election commission has come up with, and then also you have ensured, and in that solution you have also talked about the Supreme Court judgment, right? And then you have ensured to write that what more could be done. Getting a point, right? So the each and every part is very beautifully covered. Right? It is 20 marker paper, right? So the each of them at least 3 to 4 paragraph under each heading is to be written. Getting my point? समझ में आ रही बात clear है, right? So very easy question, I will say, little bit philosophical in nature, but overall the question can be said to be quite easy. Getting my point? Quite simple. चलिए आगे बढ़ते हैं. Let us come to the next point, that is your 356. Relation to emergency and relating to justification of the imposition of the precedent rule. Justification. I always talk about that whenever you write answer, talk about rationale. Why this? What is rationale basically? Justification. Right? So any topic you study in UPSC laws and syllabus, this word justification or rationale is very important to understand. Right? I keep telling whenever I check the question, that write rationale. Why this? Any question, why this? Why this provision was intended? Okay, so the same question is here, right? So let us see. Last year the question was discuss the effect of emergency. He had the financial emergency, and this time the question was 356 state emergency. So what does it say, right? So you talk about 356 very generically. 356 was intended to be the state should not behave not according to the constitution, and the intention was that the state should should not have any tendency to secede away from the union, right? So it provides a sort of a stopgap arrangement, right? And then you write what are the granular provision of it, what does the 356 says, and these and that, right? And then you go, and the provision need not to be in one page, it has to be in half page, very briefly provision, right? Quickly, right? And then you have to talk about that what is the justification behind it. That might have been true before 1980s or 1990s, where the state successionist movement might have been there, but this is not true for today, right? So in a modern constitutional democracy, you cannot say that this is something which is good, right? This is something which is good. Okay, so you have to sort of criticize this article 356, right? And you have to write that all the modern democracies in the world now no longer have these provisions. They talk about emergency, but they do not totally concentrate the power. They talk about emergency, there's no doubt about it. In USA also there is a concept of a state emergency, right? But they do not completely take away the power, right? The state machinery functions, but here the state machinery stands suspended, the executive machinery stands suspended and totally succeeded by the succeeded by the union political machinery. Okay, political executive, right? The council of ministers no longer functions. They goes into the suspended animation in the case of a state emergency, if you remember, right? So you have to justify, or sort of, I will say not justify, right? Do not justify it, right? Sort of that how these provisions are affecting Indian federalism, right? Because each region have their own aspirations, each region has their own goals, right? And the state government or the regional government is obligated under the modern norm of democracy to satisfy those aspirations. Getting my point, right? So this provision is now no longer possible to be justified, or even though it is justified, then you write that it should be severely weakened, right? It should be severely weakened, right? And add the Supreme Court opinion, right? Supreme Court have clearly provided that maladministration of the state is not a ground for imposing emergency. Getting my point, right? So Supreme Court have very clearly said that there are some questions which is political in nature. Now those political questions cannot be used under Article 356 to impose emergency, right? So that Supreme Court opinion, you can cite that these opinion also point in that direction, that it has to be used only in the extreme cases where is some notion of successionism, or there is a latent violation of the important articles of the Constitution, right? Not every article of the Constitution, right? Like suppose there is 2 cases with regard to writing, you will not say that secularism is violated and you will impose emergency. Getting my point? Understood? Okay, right? So you have to write very beautifully the introduction part, then you have to talk about the constitutional provision part, and then you have to talk about the justification part. Now remember, justification is the most important part. Getting my point? Okay, quite simple this is. Everyone, समझ में आ रही बात कि नहीं आ रही है? Yes, I can see on chat. Yes, अच्छा सुमित कह रहा है रिपीट इंट्रो. किस चीज का रिपीट इंट्रो आपने कहा सुमित? मैं भूल गया, मैंने देखा नहीं आपके मैसेज को. ठीक है, समझ में आ रही बात? क्लियर है? ओके, चलिए एक बार ब्रीफली मैं डिस्कस कर लेता हूँ, ठीक है, उसके बाद फिर इंडिविजुअली हम लोग क्वेश्चन जो है ना पूछ लेंगे सबसे, ठीक है, जो भी प्रॉब्लम होगा एक एक करके करेंगे। ठीक है अनिरुद्ध, ध्यान से समझना है इसको, ओके। एंड ऑल्सो दोज हु आर फाउंडेशन स्टूडेंट्स, ये क्वेश्चंस लिख के मुझे भेजिए आप, इफ यू आर रियली, अगर आपको सही में तैयारी करने का मन है, तो मैं आपसे ये उम्मीद करूंगा, जिनका फाउंडेशन बैच जिनका खत्म हो चुका, राइट, जो लास्ट बैच वाले हैं खासकर, मैंने उनमें भी मैसेज भिजवाया था, राइट, कि आप ये पूरा का पूरा पेपर लिख के भेजिए मुझे, ठीक है, 2 दिन लीजिए, 3 दिन लीजिए, कोई बात नहीं है, पूरा का पूरा पेपर जो है लिख के भेजिए, ठीक है एवरीवन। जो लोग तैयारी कर रहे हैं, जो स्टूडेंट रह चुके हैं, ये उनके लिए है सर, ठीक है, जो स्टूडेंट नहीं है, ऑब्वियसली जो स्टूडेंट है उनको प्रेफरेंस देना पड़ेगा, आप भी समझना, ठीक है। किसले, तुम तो खास कर लिखो ये पूरा का पूरा पेपर, ठीक है, जो जहां तक जो जो सिलेबस हो गया है, इंटरनेशनल लॉ हो गया है, वो पूरा का पूरा लिख के भेजो मुझे, ठीक है, बहुत जरूरी है। पेजेस तो इस बात पे डिपेंड करता है अजय कि व्हाट आर द नंबर ऑफ, आई मीन हाउ मेनी नंबर ऑफ लाइन दैट यू राइट इन वन पेज। कुछ बच्चे हैं बड़ा लिखते हैं तो 5 पेज भी हो सकता है, छोटे लिखते हैं 4 पेज भी सफिशिएंट है। ओके एडवोकेट अजय, एडवोकेट इज बाय द वे नॉट अ यस। ओके 3C देखते हैं, एक्सप्लेन द वेरियस प्रोविजंस ऑफ प्रिंसिपल ऑफ नेचुरल जस्टिस। ओके, वर्ड लिमिट 300 होता है। ओके हाँ किसला है, कल तक मुझे चाहिए पूरा का आंसर, वेरी गुड। चलिए तो 3C देखते हैं, एक्सप्लेन द वेरियस प्रिंसिपल ऑफ नेचुरल जस्टिस विद द हेल्प ऑफ रेलेवेंट डिसाइडर। नाउ सी दिस, so there are 3 principles, right? Do you think in 15 mark you can assimilate each one of them? Here the problem is not that you don't know the question. Here the problem is that are you smart enough to write everything in a very succinct manner? Right. So what you have to do here? You have to talk about principal justice principle. That how this principal justice principle evolved in criminal law, and it is based on mostly concept of equity and good conscience. And then you write it have, it can be described as, right, and in paragraph by paragraph, right, you write 3 4 5 at least 6 to 7 paragraph supported with the case, right. No one should be heard of judge of their own cause, this principle enunciates this full stop, in this case the Supreme Court opined it. Then you write the second principle, then you write this means this, and in this case Supreme Court opined this about this particular principle, right. So you have to very succinctly talk about almost every provision, right. You have to very succinctly talk about every provision and support it with the case laws, right, because this is not a very specific question, because this is the specific principle of natural justice that you have to talk about. Okay, right, yeah, this is the admin law question, there is no doubt about it, yes, but if you remember, admin law and the administrative law and the constitutional law is in the part A. Okay, Chale, now let us come to 4A. Again a very interesting question, right, easy question again, right. What does it say? Philosophically you have to talk about DPS. Okay, see how much, that is why I keep telling you guys, right, keep sending you articles. Philosophical aspect is very important. Why DPSP? Okay, what was the intention here? And the best thing is to quote Constitutional Assembly debates, right. That is the best thing to be quoting in the exam, that these are the while debating about this is what the court said. Okay, so that is something very very interesting. Yes, Subneet, yes, I will take the doubts in the last. Okay. Okay, so 4A, the provisions of DPSP are not enforceable by any court, but they are fundamental in the governance of the country, right. This is exactly Article 38, right, if you remember. Critically examining the role of the government to fulfill the desired objective inside in part 4 of the Constitution. How nice question. Right? Now suppose if the same question that I had given in the test series, whether DPSP have been fulfilled by fundamental right, right, or DPSP is nothing but it is an assumed fundamental right, or it is a fundamental right which could not be enforced, right. So you have to talk about the interrelationship, but here it is talking about what the government has done. So what do you have to do? Think about it. Can anyone tell me the most easiest way to write this answer? You talk about DPSP for why it was not included, because of the limited resources, but still it is a conscience keeper of the constitution, and it was intention that the upcoming government do not forget if these are the ideals or these are the concept of welfare state that we wanted to give our citizens, right. And then you write that the contemporary government had tried to fulfill it, and then write each and every DPSP as much as you can remember, and write the law with regard to those for their fulfillment. Like everyone should be having a job, talk about Manrega, right. Labor welfare, talk about the Minimum Wage Act. Labor welfare, you can also talk about the this recently with regard to pregnant women, the The total leave duration have been increased. Similarly, talk about youth, protection of youth, etc., etc. Talk about different laws with regard to protection of youth, prevention of offender act, etc., etc. So what you have to do, that you have to write individual DPSP and the government law or the government policy which is in direct consequence of the fulfillment of that DPSP as much as you can. It is a 20 marker question. So I think at least you can cover 9 to 10 principle of DPSP, any one of them that you remember, right? And the law connected. Clear hai? Everyone, okay, right? So what you have to do, talk about DPSP philosophically, then take individual DPSP and the law in the which have been made in the consequence of that DPSP. Quite simple. ठीक है ना? तो ये point जो है ना बड़े अच्छे से है ना आपको यहाँ लिखना था. And also I will try, if possible, I will not promise because new batches are starting and I will become a little busy, right? But I will try to have a sort of a model answer for all of these. Okay. Chali, let us come to 4B. What is 4B? Examining the role of a state legal service authority in promoting legal literacy and the right of women and children in the state. Right? How easy this question is. This is a question related to State Legal Service Authority Act, right? And then you have to talk about what is the constituent of that State Legal Service Authority, how the Chief Justice of India is the patron in chief, right? And what is the responsibility under the Legal Service Authority Act? Specifically, they have been provided that these are the responsibility of them. Now, one of the responsibility of them is to promote legal literacy by organizing seminars, by organizing talks, by organizing talks with regard to children, and then with right to women, you provide that how the State Legal Service Authority provides the list or the category of the applicant whereby the legal service would be given free of cost, right? So person or the child abused is by default in one of them, and any women, right? With regard to women, even there is not even a criteria that what should be the income of that woman, right? So theoretically speaking, even Anil Ambani's wife is eligible for legal service authority. In the case of male, there is a criteria with regard to income, but in the case of female, it is simply women, any woman. Okay, so that is what you have to write it down, right? It's a very typical question, to the point, right? And I think again it is one of the part of the notes also, right? Where I have provided with the I will show you also, right? That will be much better actually. Let me show you. Give me a minute. Because right, like this particular, can you see this notes, everyone? Yes. Okay. This question, this is a concept of public litigation. Here I have talked about this is where the public this PIL part would have been covered, the question of philosophy. Now this is the legal aid, okay, right? In that legal aid, one of the concept is of, in the case of legal aid, right, one of the concepts is of this Legal Service Authority Act. Can you see this, right? So in this Legal Service Authority Act, right, I have very clearly given here when you are liable for free legal aid, right? When you are liable for free legal aid. Okay, now this is what the free legal aid is all about. Obviously, Mr. Sumit, no, this is intended for foundation batch student, right? So how can I give you, right? It is simply not possible. Okay, similarly, Legal Service Authority, like see, National Legal Service Authority, right? So what are the functions, right? So Chief Justice of India in this, in the case of a State Legal Service Authority, we'll come to, there's a, see, state, this is actually the answer, see? This is actually the answer. The State Legal Service Authority, who is the patron in chief, what is the member secretary, right? And what is the ultimate functions of a state authority. This is what the answer is exactly. Okay, getting my point? And then we come to the district legal service authority, right? So very easily, right? You could have written this answer simply by reading at notes. That is why I tell you, right? Reading of notes is quite important and quite easy actually. Now let us come to next question. That is your 4C. What do you mean by doctrine of separation of power? Right, again a very easy question, right? Doctrine of separation of power. Now, how to approach this question, right? So let me first read the questions. What is meant by doctrine of separation of power, question mark, is the strict adherence of the doctrine possible under parliamentary form of government? Discuss with the help of relevant case, right? First, you have to introduce this question by writing about doctrine of separation of power, citing Monson. What he understood by the doctrine of power, why he thought the doctrine of this separation of power is important, right? Then you talk about doctrine of power under parliamentary system. Yeah, doctrine of separation of power, the parliamentary system. And then you have to talk about that how it is not possible to have a complete strict separation of doctrine of power, separation of power. Why? Because then you will start talking about this particular question, right? This particular concept. And a very interesting question was there, right? Let me actually give you. I have said to that student also, Vikas, his name is, right? He have written a very interesting answer. Vikas, test number 5, if I remember correctly, right? Vikas, test number 5. So he have written a very nice answer. What he have done actually, where is Vikas test? It is test number, no, not test number 5, test number 2. So what he have done, there was a similar question in which I wrote, the question was that doctrine of separation of power has not been strictly adhered to the Indian Constitution comment. That was the question in the test, right? So what he have done very beautifully, that he have taken a, made a this like this, right? And what he have done, that he have written here, judicial power, executive power, and legislative power. And then he have written that how executive have judicial power and legislative power. Then he have written that how judiciary have executive power and legislative power, right? By citing different articles. So how beautifully, very nicely, you can say that absolute rigidity, right? Absolute rigidity. Oh, Vikas is there. Okay, yeah. Vikas is there. I wrote it today on the first half of a page. Yeah, very good, Vikas. Now I remembered this concept. Very beautiful concept. I liked it, right? So this is what very nicely you can come up with, right? Right. Very nicely you can write with regard to this, that how in a different aspect, right? Different aspect of the constitution can be given in that respect, right? How it has not been adhered into the strict format. Okay, this is a very good way. Now I discuss with the help of multiple cases are there with regard to it. So that part is, you can cite multiple cases. The best is, I think, the concept of executive power, right? That how do you determine executive power, or what do you mean by executive power, right? So it is very tough to determine. What is that name of the case? State of Punjab. Right. So there are two very important cases with regard to it that you can write. Getting my point? Okay. Yes, Vikas will send to all of you, right? Please contact Mr. Vikas. Yeah, Ram Javaya Kapoor. Yes, Vikas, very good. Ram Javaya Kapoor. I forgot about it. Okay. Now let us come to the, now if we talk about the whole, paper of constitutional law, I will say that the question was very to the point, right? And not only to the point, but it was so easy that even by, I think, looking at the answers, right? Because I think would agree, right? Even at the looking at the answers of the test paper that I took, right? That I think would be sufficient to answer this question. You need not to even read anything. Simply look at the solution of that. Right? It will be sufficient, right, to answer this question. Right? It was so easy actually. It was so easy. Okay. Now let us come to the section B, that is your international law. Now, this first question was sort of a very easy question in the sense that you have to talk about that how it evolved, right? How actually it evolved, right? To talk about Grotus law of, right? Grotus international law, right? Where they talked about that law of sea is basically law of humanity. And it should be governed by every person of the human being, right? Now, as the trade and commerce increased, a need was felt to govern it, right? Now, before coming of United Nations, right, those were governed by multiple conventions. There was a Berlin, I think, convention, right, where it was governed. And later on, right, multiple UNCLOS Convention 1, right, UNCLOS Convention 2, you write that how these conventions progressively govern each aspect of the international law with regard to sea. Getting my point, right? So with regard to, not sea, with regard to international law, right, then you talk about multiple other evolution with regard to different aspect, right? For the state succession, you can write that how the evolution started. Similarly, you can write with regard to law of sea, I have already given you, right? Similarly, with regard to state success, okay. Similarly, with regard to recognition, you can write how it have evolved, right? So what you have to do, we have to very generically talk about. You see, initially it was ungoverned. Later on, with the increased trade and commerce, with the increased interaction with different state, right? Ultimately, we achieved a situation whereby we need a complete codification, which started to occur more frequently, right? Yeah, more precisely after the coming of UN. right, after the coming of UN. Okay, and then you write, on clause, you can write state recognition, you can write multiple subject of international law, you can cite as an example. Right, it's a very generic question. There is no, fixed format that you can change by yourself according to you. Then these two theory, repetitive question, every time this question is asked, I need not to write dualistic transformation theory, monistic theory. I think everyone can write this, right? Yeah, you can write WTO also, Purnima. That is also, you can write that. Okay. So I will come. I will come. Let me complete. मैं एक ही पेपर आज करूँगा, एक पेपर मैं कल करूँगा, ठीक है ना? एक ही पेपर मैं आज करूँगा, ठीक है? Okay. Similarly, 5B, I think need not to explain. Very easy, right? 5C, double criminality and rule of spillage. The double criminality in the case of extradition. See, when you talk about extradition, in fact, when you talk about any concept of international law, one thing is very certain, that you write that how international law is more governed by the internal policy of a particular country, and extradition is no different, right? So these are the two principles with regard to rule of speciality, right, and with regard to rule of double criminality, right? That you provide, these are the offenses in which if both of them, if it is an offense in both of the country, we will give the extradition, right? Sometime international humanitarian principle is also taken into account with regard to extradition, right? So you don't need to go into that detail. You talk about first extradition, how it depends upon two countries, right? Give and take, and then you individually describe these two rules. No need of case, nothing, right? If you want, you can talk about the recent, Nirav Modi and what is the other name, right? How it have been quite difficult because double criminality principle applied, and the things which was illegal in India was not illegal in the countries like Cyprus, where we have more and more law with regard to finance, right, which is more open, right? It is not so more secretive, right? And their laws is not as strict as we have in India, right? That is why we are facing some problems there. Okay, so that is stuff you can cite an example, right? More than that, not required. It is a 10 marker question, right? So even if you write one paragraph for each one of them and extradition in little bit detail, it will be more than sufficient. Hardly you have to write 3 to 4 paragraphs. Similarly, define double nationality and statelessness, right? Now, I already, if test student we are right, I always tell them whenever there is a question of nationality, always a statelessness is included. Because loss of nationality is stateless. If you look at the syllabus of UPSC, there also it is nationality and stateless, right? Getting my point? Again, it is a repeated question. Ashish, yeah, is one of the student, I think, right? He knows it is a repeated question. I have given you in the exam, the notes also, right? So again, you talk about nationality, right? One of the methods to prevent statelessness is actually double nationality. Okay, if you provide someone nationality from in the countries where they may migrate, right? So if you provide nationality to them in both the countries, that may reduce sort of the statelessness. Okay, so that is one of the thing, right? Now evaluate the effort with regard to them. You write that effort is very less, and mostly you will cite the recent crisis whereby a wave of migration took towards the west. Okay, and Western people did not actually accepted much of them, right? From Syria, you must have seen that a child who's drowned, right? So it has become quite an important thing, right? And it has become one of the principle of international humanitarian laws that once a stateless person is at your border, you will first, whether to take that particular person in border or not, that is irrelevant. First, you have to take them within the border, and then you have to decide that whether you will give them refugee status or not. Right? You will not allow them to just stand on your border. Okay, Mexico and US crisis also you can cite here. Okay, so very nicely you can write that down. Similarly, what is intervention? Very nice question, right? Intervention can be of two types, right? Active and passive intervention, right? Intervention itself, mostly it is active in nature. Passive intervention is just a misnomer, but for the sake of understanding, you can write. And then what are the grounds, right? So there are two major grounds, right? First, existential threat is there, okay, on which you can write, and there is a preemptory, right? There is a preemptory attack, right? So it means that if there is an imminent attack, right, and that attack is something which is existential threat, then you are justified in intervention. Okay, India ka example denge ki there was a preemptory attack, right? There was very imminent that someone from Pakistan will attack, so that India took action to do it. Okay, so that are the two major justification, okay, that you can write. Intervention is there in the syllabus. One of the methods, peaceful settlement of dispute, right? There is one, settlement of dispute. There are two methods, Purnima. One is the peaceful, and another is the coercive. Okay, if you are a foundation student, Purnima, right? I have taught you this, if you remember. Yes, Purnima? And in fact, I have shared you a very beautiful booklet also with regard to this. Yes, lawful recourse to force. Very correct. Very correct. They had a very beautiful, article also with regard to intervention, right? What is the justification? There are two major thought process. If that is there here, I could show you right now also. That's, yeah. So that is very important to study, right? So please keep that in mind. Admit it. I think that is there. Let me show you also. I mean that way you will be, sort of, it will be good for you also. Where is that handout? Yes, this is the right of self-defense. Let me show you all that. That is actually quite good. Yeah. Yes. Can all of you see this? This right of self-defense and international law. This is a class handout I have given you in the foundation batch, if you remember. Right. So there, I have talked about right of self-defense, this Caroline incident, right? Preemptive self-defense that I was talking about, right? Preemptive. And then, you have to cite the article of the UN Charter, right? That is Article 51. This Article 51 talks about, yeah, there are two groups of interpretation. One group of interpretation says it is not applicable when there is a, only threat of military attack, and one says that no, only when actual threat is there, then only it is applicable, right? So there are two group of a scholar, right? Now, what are the limitations? So there are three type of limitations, and there is one limitation under the international law with regard to, international humanitarian law limitations, right? So this, I think, very nicely I have talked about this question, right? So remember it. That was the question also there. Okay. So this I think I have shared with the foundation students, right? I have shared this. Yes. Very important. This. Okay. So this one handout, one question. 15 marker is done. Very easy. It is hardly two-page handout, right? So more than sufficient. Okay. Now let us come to recognition, right? So I have given recognition is a political act comment, right? In our test series question, right? And this is a question which I repeat every test actually, because if there is a question on recognition, there are only two type of question that is asked: de facto, de jure, or whether the recognition is a political act. That is the two questions from recognition. Last year I have asked de facto, de jure. It came in the exam. This year I knew that won't come, right? So this year I asked whether it is a political in nature or not. Right. So again this question was, yes, in IL, the questions are very much repeated actually. Nothing new comes, right? It is all the old things, right? That is why I say law optional is a perfect optional. Okay, so I don't think I need to talk about it, right? There are two theories, and also what is the meaning of recognition in detail. Okay. Yes, Ashish, very correct. I totally agree. Similarly, 6B, what do you understand by state success? And again, there is one of very important theory, right? One of the theory is the clean slate theory, right? The new state starts with clean slate. Okay, another is not, where this new state is actually assumes the rights and responsibility of the previous state. So there are two major theories, right? Similarly, state succession explain the rights and obligations. Now, if you remember, I have told you with regard to right and obligation, make notes that this right and obligation arising out of the successor states with regard to what? So with regard to contract, right? With regard to foreign assets, right? With regard to debt, with regard to archives. Okay, so what you have to do, that you have to talk about rights and obligation of the successor state with regard to what? Because generic right and obligation do not arise. Generic right and obligation do not arise. It varies with regard to what. So in this question, what you have to do, that you have to talk about right and obligation, and then you have to talk about the right and obligation varies as per the subject concerned, and then individually you have to write how the rights and obligation will lie. Because if you remember, I have this question, I have specifically told you this question was there in the test series, right? That these are the rights and obligation, and this is how it will lie. Okay, yeah, Taliban and power can be cited, but that is one of the example of a state succession, right? So that rights and obligation not in that respect. Okay, so quite simple this is. Similarly, come to 6C, main feature of law of C, right? What do you mean by main feature, right? You have to talk about on clause 1, 2, 3, and what are the major provision of them, right? What is the difference between jurisdiction of a territorial sea, exclusive economic zone? When you talk about in the territorial sea, it is the extension of the actual territory. In the case of exclusive economic zone, it is only the economic aspect that is covered. Okay, that is the primary difference. And then individually write what are the type of jurisdiction that the state exercises. In the case of exclusive economic zone, to repeat it, it is the economic jurisdiction. It means you have right over the mineral. you have the right over the exploitation, you have right over the any marine resources. In the case of territory, below as well as above that particular territory, and that is your air right, that also parcel of your normal territory. Okay, so that is the major jurisdictional difference. Okay, criminal law applies here, criminal law may not necessarily apply in the case of exclusive economic zone, right? So that is the jurisdiction that you will write. Jurisdiction vary as per the subject, and in the case of exclusive economic zone, it is most the economic rights that the state has the jurisdiction of. Getting my point? And that is the very simple difference between those two. Then 7b discuss the 7a discuss the power of Security Council for maintenance of world peace and security. Right? Have to talk about a specific provision of the UN Charter, that how Security Council have the ultimate responsibility of providing for international peace and security. Okay, then you have to tout the exact provisions saying that if the matter can be brought to the Security Council in two ways, right? By reference by the General Assembly, or the Security Council can take their own cognizance, or any member of Security Council can bring it to the attention of Security Council. Now, once the Security Council have seized it, right, then it will recommend the things that may be done for the purpose of that particular incident, right? And that has to be followed by individual state, and that is not mandatory in nature, but the states are supposed to follow the decisions of Security Council. And then you will write how these decisions are becoming more and more political in nature, right? Because it will depend upon the relationship of the states, right? And then specifically with regard to veto power, right? So you have to sort of criticize veto power in that. Okay, so what you have to do? Talk about Security Council, how it has the primary responsibility, and the UN Charter provision. You have to specifically write Article 52, Article 43, Article 47. You have to specifically write about it. These are the modes through which the security power will take the cognizance, and then the decision making process. Yes, again the article, and then how it has become more and more political in. Getting my point? Understood that particular point? Okay. When the Security Council takes decision, and when you authorize the law, use of force by the Security Council, there the veto power is again, one of the hindrance, because once the veto is done, that particular decision of the Security Council cannot be given effect. Right, so it merely becomes a morality, sort of a recommendation, nothing else. Okay, so this is a highly political type of question. Similarly, 7b, yeah, very correct, that can be cited, very correct. Similarly, 7b, discuss the United Nations Declaration on Establishment of New NIEO, right? Very philosophical in nature question, along with the Charter of Economic Rights and Duties of the State. So along with NIEO, one of the resolution have been passed. You have to simply cite the resolution. Now, if you do not remember the resolution, I have told you there are three major points of NIEO. What? Recognition of historical responsibility, preferential trade access, and not demanding of reciprocal treatment. So these are the three pillars on which NIEO is based. If you do not remember the exact provision of NIEO, at least you should write this. If you remember, in your foundation batch, I have already discussed this. Okay, and then the charter, what are the economic rights and responsibility? Chapter 4 of resolving dispute. Very correct, Ashish. Yes, very correct. Okay, let us come to 7c. Humanity is in peril in the present world due to terrorism. I have asked the question, discuss international terrorism in present day context, right? And now this actually have asked you to sort of club the understanding of international terrorism and human rights. Okay, like I have asked a question, if you remember, in the final, the full length test, that terrorism leads to human right violation, full stop, comment. Okay, now these two questions, right, is connected, although the wordings are different, right, but the substance of the answer would remain. Human rights essentially violates terrorism essentially violates human right, comment. Now this question in the test series and this question, the substance of the question remains the same, that you have to find or write the connection between terrorism and human rights. Now, how will you approach? And then various ways to protect it, right? So how will you approach it? We talk about first the word terrorism, define it, right? Purpose is to, it has come from the word terror, right? The purpose is to tremble, right? So the purpose is to send the message so that a person starts to tremble in fear. So not necessarily harm a person, but to send a message, right? So, and then write that how it has been used as a political tool recently. And then you talk about it has taken multiple form, right? And cross-border terrorism, state-sponsored terrorism, all those things, you will mention. And then you write a separate heading. There's the introduction part, right? At least 2 paragraphs with regard to terrorism. Then you write terrorism and human rights. Then you talk about how terrorism essentially violates human right. Okay. And then you write that how this state-sponsored terrorism, specifically or cross-border terrorism, specifically poses a new challenge with regard to human rights, especially in the case of its prosecution. Okay, and then you talk about your way forward, that what can be done, right? So there are 3 things that you can specifically talk about here, right? 3 things. Remember, first thing that you can specifically talk about is the making international law much more rigorous. Second, making terrorism a crime which is can be considered animus parandi. It means it should be a crime against humanity. Okay, terrorism should be considered a crime against humanity. And third thing that you may write there, that you can talk about strengthening of the mechanism of international criminal court to prosecute terrorism. Right now, international criminal court prosecutes some of the crimes which is provided in the charter, crime against humanity, etc., etc. But terrorism is specifically not provided, right? So these are the 3 things that I can think of right now, right? You can come up with multiple other things where you can say that this can be used to strengthen the international prosecution of international terrorism. Okay, this is again a very generic question, required a very generic answer, right? Even though no case law is here is required. Okay, you might cite some of the provisions of any terrorism law, right? But you need not to specifically cite any case. Okay, it is quite simple. Write a more generic answer. Then let us come to 8A. Now today I will discuss paper 1 only. Paper 2 I will discuss tomorrow, or day after if I will have some time, because tomorrow I have to start with the foundation batch, right? So tomorrow I will have multiple other classes also, right? So first let me start with it. Then after a week or after 2-3 days I will discuss paper 2. Okay, all of you be there same time around at 8 p.m. I will discuss it. Okay, remember. Then let us come to 8A. It says it is a legal duty of a state to settle their dispute by peaceful means. Answer is no, there is no legal duty. Sorry, answer is yes, there is a legal duty, but it is not compulsory. It is not a mandatory legal duty. Right? See, the very nature of international law is that it have been provided in a manner where the state do not feel like my sovereignty is being compromised. So we have recommended that you will try to settle your dispute by peaceful means, but those are not mandatory in nature. So answer will be yes, but it is not mandatory in nature, right? So that should be the part of your answer. Now, can failure of peaceful means entitle state to use force to settle their disputes, right? So the answer is again no. You have an obligation to talk about the peaceful means, right? And when you talk about the use of force, right? Article 52 of the UN Charter provides only in 2 scenarios you can talk about the use of force. Either there is an imminent threat or there is an actual threat. Either there is an imminent threat or there is an actual threat of attack. Okay, getting my point, right? So first you have to talk about international law. What is the concept behind peaceful settlement of dispute, all the UN provisions, right? And then you have to talk about there is a legal duty, but it is not mandatory in nature, right? Then you have to come to the second part of the answer, and then you have to write failure to settle the dispute by peaceful means do not necessarily indicate that you have to go for the forceful means. Under international law, then you will cite the article, the PDF just I showed you, right? That under international law, there are only 2 scenario. Either there is an imminent need, imminent threat, or there is an actual armed attack. Then only you will try to resolve dispute by non-peaceful means, right? By an act of aggression. Okay. Again, a very quite simple question. Again, I think. Now let us come to 8B. Is the threat to use nuclear weapon under any circumstances permitted under international law? The answer is the opinion of ICJ with regard to this, and the opinion primarily the ICJ says that they do not say that threat is okay. They have said it negatively. It said there is no international legal principle or legal document which prohibits the threat. They're not saying it is legal. They're saying that it do not prohibit it. Getting my point? Okay, right? But under international humanitarian law, it can be. Right? Under international humanitarian law, it can be, right? And then answer the question like advisory. So what you have to do simply that you have to talk about the advisory jurisdiction. You simply read the advisory jurisdiction PDF, hardly 2-page PDF, and take important paragraph from it and simply keep write them down. It is not very tough. I think in foundation batch I have very clearly dictated also. These are the 5 paragraphs. Just remember it. And whenever there is a question, either there is a threat of nuclear weapon or use of nuclear weapon, advisory opinion, and you write those 5 paragraphs. That is more than sufficient. Getting my point, everyone? Yes. Quite simple. Okay. Now discuss the role of United Nations protection of human environment. Again, there could not be any question much easier. Protection of human environment, and this is a specific topic, right? So Mr. Ashish will tell me, or Mr. Ashish Moore, tell me, or Purnima also, foundation batch, all students, tell me which particular UN convention here you will talk about. Yes, or which particular conference you will talk about. Tell me. Hardik also can tell me here. No, 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 no. Anyone else? Shivani? किसले? स्टॉकहोम, वेरी करेक्ट। किसले? ऐसे कैसे भूल जाओगे यार तुम, मतलब गलत बात है ये, ठीक है ना? स्टॉकहोम कॉन्फ्रेंस लिखना है, ठीक है? और वहां से लिखना है कि व्हाट आर द मेजर प्रिंसिपल्स ऑफ स्टॉकहोम कॉन्फ्रेंस, राइट? एंड देन हाउ दैट स्टॉकहोम कॉन्फ्रेंस हैज लेड टू डेवलपमेंट ऑफ मल्टीपल ऑर्गेनाइजेशन, जो आपने अभी साइट किया यहाँ पे, ठीक है? अर्थ समिट, यूएनईपी, ठीक है, यूएनएफसीसी, ये सब के सब स्टॉकहोम कॉन्फ्रेंस के प्रिंसिपल्स है, और वो लीड करता है मल्टीपल, मैंने बताया था आपको क्लास में, याद होगा, these are the major principles of the Stockholm Conference, right? And those principles has led to individually establishment of multiple what? Multiple institutions, जो भी आप साइट कर रहे हैं, ठीक है ना? वो बड़े अच्छे से, हाँ, स्टॉकहोम वाली अच्छे से आपको लिखनी पड़ेगी, ठीक है ना? समझ में आगे बात ये है, राइट? सो क्वाइट सिंपल इट इज, ओके, वेरी क्लियरली। चलिए, तो पेपर 2 बाद में डिस्कस करते हैं। लीगल इंसेनिटी तो पूछा ही, मैंने पढ़ाया ही, अभी मैं में पढ़ा रहा हूँ, अगर याद होगा आपको, ठीक है ना? तो वी हैव ऑलरेडी गिवन इट, ठीक है, उसको बाद में डिस्कस करते हैं, ठीक है ना? चलिए, अब इंडिविजुअली आ जाते हैं क्वेश्चंस में, ओके? यस, इंडिविजुअली क्वेश्चन में आ जाते हैं। 3 लेक्चर्स जो, अच्छा, वो मैंने बीच में जो स्टार्ट किया था यार, वो मैं भूल गया। आई विल रीस्टार्ट इट। एक्चुअली आई गॉट कोरोना इन द मीनवाइल। मैंने सोचा था कि एक हफ्ते में कंप्लीट करूंगा, लेकिन कोरोना वाला मामला हो गया, थोड़ा गड़बड़ हो गया। बट आई विल, ओके, आई विल। ओके, चलो फिर तो आगे बढ़ते हैं। क्वेश्चंस पूछना शुरू कीजिए आप लोग, एंड आई विल सॉर्ट ऑफ शेयरिंग मैं बंद कर देता हूँ। चलिए, बताइए, आस्क योर क्वेश्चन। यस, तो कौन आएंगे? फर्स्ट सुबनीत। यस सुबनीत, आई हैव अनम्यूटेड यू, गो अहेड, आस्क योर क्वेश्चन।
Hello.
Yes, go ahead,
Am I
Subnit.
audible, sir? Thank you, sir, for firstly for
Yes, India
organizing
participated
this.
in it, yes, and
It's
you
very
cannot necessarily say that India introduced the concept of sustainable development, but yes, India was one of the important signatory of it. Akshara. Yes, go ahead, all
hello,
of you.
sir.
I cannot hear you, Navneet. I think Subnit, you're.
Hello.
I cannot hear you. No one
Hello,
can hear
sir.
you.
I'm
Can anyone
Shubneet.
hear Subnit? I think no. You can
Hello.
ask in the comment itself, right?
Hello, sir. Hello, sir.
Go ahead. Go ahead.
Hello. Am I audible, sir?
I cannot
Am
hear
I audible?
Navneet or Subnit. I don't know why.
Am I audible, sir?
मुझे क्यों नहीं आवाज आ रही यार? ओह, सॉरी सॉरी सॉरी,
Hello,
एक मिनट।
sir.
हाँ, अब आ रही है। सॉरी सॉरी, प्रॉब्लम थी, बताइए।
Hello, sir. Am I audible? Am I
Yeah,
audible?
you're audible. You're audible, Subnit. Please go.
Thank you, sir, firstly for organizing the session. It's very helpful, sir. Second, sir, मैंने ये पूछना था, like अगर हम जो 10 मार्कर आंसर लिखते हैं, तो उसमें सर हमें नेसेसरीली कितने केसेस, लाइक 3 केसेस मेंशन करने हैं, और 20 मार्कर में 5 केसेस मेंशन करने, लाइक ये
नहीं, ये उस
कंपलसरी
पर
है?
नहीं, ऐसा कोई प्री डिटरमाइंड फ्रेमवर्क मत बनाइए। अगर कोई फिलोसफिकल क्वेश्चन है, ठीक है, तो उसमें एक पोस्ट भी मेंशन करें और उसमें जजेस के स्टेटमेंट आप मेंशन कर दें, मोर देन सफिशिएंट, ठीक है। लेकिन हाँ, जहाँ पे स्पेसिफिकली कहता है इन लाइट ऑफ डिसाइडेड केसेस, वहां 2-3 केस मेंशन करना जरूरी।
ओके ओके सर। दूसरी सर, जैसे हम जो लॉ ऑप्शनल हमारा पढ़ते हैं, उसमें सर जैसे कॉन्स्टिट्यूशनल अमेंडमेंट्स डिबेट्स हुई थी, तो सर अगर कोई ओपिनियन बेस्ड क्वेश्चन आता है, उसमें हमें लाइक डॉक्टर बी आर अम्बेडकर या कोई और में, तो वो साइड करनी मतलब चाहिए? ओके
जरूर,
सर,
बिल्कुल चाहिए, उससे बड़ा अच्छा मतलब इम्पैक्ट पड़ता है।
ओके सर। एंड सर वन लास्ट क्वेश्चन, जो हमें जो एक ऑप्शन, एक जो क्वेश्चन होता है, वो हमें दोनों सेक्शंस में से किसी एक को उठाना होता है, एज अकॉर्डिंग टू यू सर, हमें कौन से सेक्शन से लेना चाहिए? अगर आईएल पहले पार्ट
ये
से,
ये
या
बड़ा
फिर
ये बड़ा ही डिस्प्यूटेड है, मैं बच्चों पर छोड़ देता हूँ, ठीक है। कि अगर आपको बड़ा पसंद है आईएल, ठीक है ना, तो आईएल 150 नंबर का कर लीजिए और 100 नंबर का कॉन्स्टिट्यूशन कर लीजिए। लेकिन आपको अगर उल्टा पसंद है, आपको लगता है नहीं कॉन्स्टिट्यूशन के क्वेश्चन सब ज्यादा अच्छा लिख सकते हैं, जनरली बच्चों को लगता है कि हम कॉन्स्टिट्यूशन ज्यादा अच्छे से लिख सकते हैं, ठीक है ना, तो आप
सर वैसे
कॉन्स्टिट्यूशन के 150
पर्सनली
नंबर के लिए।
आप एक बार कौन सा
मैं
लेते,
तो
अगर
आईएल पे
आपको?
सजेस्ट करता हूँ, देखो, पुराने क्वेश्चन रिपीट होते हैं, आईएल के क्वेश्चन करना इजी होता है, ठीक है
ओके
ना?
सर, ओके
हाँ,
ओके,
मैं पर्सनली
ठीक है,
ये सजेस्ट
थैंक यू
करता हूँ,
सर।
लेकिन दूसरे वाले में ओपिनियन नहीं, क्योंकि दूसरे वाला बड़ा सब्जेक्टिव है, उसमें फिर आपका पर्सनल चॉइस इंपॉर्टेंट।
ये सर आईएल में मोस्टली रिपीटेड होते हैं क्वेश्चन।
बहुत रिपीटेड होता है उसमें, तो प्री डिटरमाइंड आंसर बना सकते हो कि भाई ये टॉपिक है, 4 क्वेश्चन आते हैं, चारों का आंसर बना दो, खत्म। ठीक है ना? इजी।
ओके ओके, थैंक यू सर, थैंक यू।
अब सुमित, यस सुमित, गो अहेड, पूछिए अपना क्वेश्चन।
Hello, sir. Good evening. Am I
या
audible?
गुड, यस यस यू आर।
Sir, my question is like, sir, I have changed my optional to law only this time around. Earlier, I have given with different optionals. So, what should be the approach right now? Like, I have prepared for judiciary, but can you suggest the book list or notes how to
अगर
go
मैं
about it?
सिंगल पॉइंट में आंसर दूं आपका, ठीक है
Yes.
सुमित, तो पुराने क्वेश्चंस लीजिए टॉपिक वाइज, ठीक है, उस टॉपिक वाइज क्वेश्चंस में देखिए कि कौन सा क्वेश्चन रिपीटेड है, ठीक है, और उस क्वेश्चन का एक लिस्ट बनाइए। मेक अ लिस्ट ऑफ रिपीटेड क्वेश्चन ऑफ ईच टॉपिक, हार्डली देयर विल बी 3 to 4, ठीक है, एंड जस्ट मेक और अंडरस्टैंड दैट पर्टिकुलर क्वेश्चंस टॉपिक जो पूछा गया है, नथिंग मोर इज रिक्वायर्ड। रेडीमेड आंसर्स बना लीजिए कि ये आएगा और ये लिखना है। समझ में आ रही सुमित आपको बात? ठीक है ना? तो दैट इज द ओनली, अदरवाइज व्हाट यू कैन डू, यू कैन अटेंड दैट कल फाउंडेशन है, ऐसा करो कि मैं फाउंडेशन सुना ये भी फर्स्ट लेक्चर में सबके लिए ओपन कर देता हूँ, ठीक है, इससे ना एक बड़ा आसानी से एक वो बनेगा कि हाउ हाउ टू स्टडी, ठीक है ना? चलिए मैं बोलता हूँ डिफेक्टिव वालों को, राइट, कि फाउंडेशन वाली जो पहली क्लास है, राइट, मैं आई विल कीप इट ओपन फॉर एवरीवन, ठीक है, इससे जो है, क्योंकि मैं पहली क्लास में यही बताता हूँ मोस्टली, ठीक है, कैसे पढ़े, तो दैट विल बी मच बेटर, ठीक है, मैं कल फाउंडेशन वाला मैं कहता हूँ कि भाई ओपन टू एवरीवन करते, ठीक है ना? चलिए, नाउ लेट अस कम, पूर्णिमा क्वेश्चन पूछ रही हैं। यस पूर्णिमा, बताइए, गो अहेड।
सर मेरा जो मेजर क्वेश्चन है वो रिलेट कर रहा है कि व्हेन शुड आई स्टार्ट आंसर राइटिंग, क्योंकि अभी मैं कॉलेज
फाउंडेशन के स्टूडेंट है, राइट?
यस सर।
मुझे पेपर 2 मैंने आपका आईएल खत्म कर दिया है।
यस सर।
आईएल के आंसर्स मुझे परसों चाहिए।
सर बट एक्चुअली बात क्या कि हमारे एग्जाम्स आ रहे हैं ना, सेमेस्टर के
कोई
एग्जाम।
बात नहीं, सेमेस्टर के एग्जाम चलते रहते हैं जीवन में, ऐसा नहीं है सेमेस्टर के एग्जाम में पढ़ के तुम एकदम वो कर रही हो, ठीक है, उसमें से समय निकालो, वैसा थोड़े कि 24 घंटे पढ़ती है, उसमें से समय निकालो एंड यू राइट। वो सब सारे फाउंडेशन वालों को है, जो जो इस बार बैच चल रहा है सबका सब मुझे लिख के दिखाएंगे, ठीक है ना, जो इस बार 22-25 स्टूडेंट है सबके सब, ठीक है, किसलिए ने बोली दिया और ये आपकी भी जिम्मेदारी है, अनिरुद्ध ऑल्सो, ओके, तो सबके सब फाउंडेशन वाले मुझे इंटरनेशनल लॉ के क्वेश्चंस के पूरे आंसर्स लिख के दिखाएंगे। हाँ, भले ही मैंने जो वीकली जो मैं क्वेश्चंस देता हूँ वो आपने लिखे होंगे, कोई बात नहीं, छोड़ दीजिए उसको, यू राइट इट अगेन, ठीक है ना, मुझे आप लिख के दिखाइए, ओके पूर्णिमा, नो क्वेश्चन। हाँ, रमन्ना बताइए, यस रमन्ना, गो अहेड।
Good evening, sir.
Yeah,
Sir,
good
is there any batch for answer writing specifically? Are you
I
going to
used to
start?
take one batch of answer writing, right? But it becomes
But I
quite,
have missed that.
hideous for me. Yeah, quite hideous for me, right? So I have stopped it, right? So test series I have, right? So if you have studied and you think you need it, you can join test series. Answer writing, it is same thing, right? I thought that answer writing, little bit, I will give 5 questions, per week, and I will, but that is not much feasible because that becomes quite less and do not become quite rigorous. Test series is quite rigorous, right? So that is much better because each test series there are 7 to 8 topics. So you study 8 topics in 2 weeks and give the test, right? So that I think is a better thing.
Sir, is there ongoing test series, sir?
Yeah, that is the last one itself, right? New one I will make when it is 2021, but that doesn't make difference, right? Because ultimately 80% question remains the same. You also know, right? 80% question, because UPSC itself 80% question remains the same, right? So it doesn't matter. So if you want to write this time also, that's okay.
Okay, sir. Thank you.
Okay. सुमित हो गया एक बार क्वेश्चंस में पूछना, ठीक ना? भवेश, yes Mr. Bhavesh, go ahead.
Good evening, sir. Am I audible, sir?
Yeah, you're audible, Bhavesh.
Thank you so much, sir, for granting me this opportunity. So my question is that I have done self-studies. Basically, I am a law graduate and I have completed my syllabus by standard textbooks. But sir, when I see these questions and when I listen these discussions, although questions were being repeated, but how I can make value addition to my own answers? Like if there is some topic in the constitutional law itself, there are like fixed cases. So how I can like do some value addition? What should I refer now? How should I improve on those things?
Tell me one thing. Why do you want to do value addition? What is the problem in referring the important cases of that particular question?
So, if there is some, for example, if there is topic on right to equality, So if I am able to recollect, there are 3-4 cases. So is that sufficient if we refer to the traditional cases, or do we need to add something?
See, what I do for that, a very good question. Traditional cases you have to refer. Then what you do that in recent time, if the new cases has come, which has quite been news. If you remember, just before mains, I have published, by looking at live law collection, multiple cases and relevant topic in which it can be cited. So what you do that you prepare traditional things, and last 2 years you simply go on de facto law website, and I have clearly given these are the important cases which, if it is connected to your topic, you cite them. Because every time there's a judgment on right to equality some way or other, right? Now, it is not humanly possible that every judgment of the Supreme Court right now is connected with equality. So you cannot possibly, write each and every judgment of them, and it is not desirable also. Okay,
Yes,
so you simply write, 1, 2 that you could remember recently. Okay, nothing more. And the traditional one, right? So traditional one, and just as an example, recent one. Do not go and write the recent one as the more important one, because that recent one would have referred to one of the judgment that you have already remembered. Getting my point?
Yes, sir.
Yeah, so do not fret about it. If you remember traditional part also, that is more than sufficient, and recent few, 1 or 2 of them is okay. Right? Do not go and fret about thing again and again. Not needed.
Sir, one more thing I wanted to ask. Sir.
Yes, go ahead.
Sir, like how to handle the philosophical type of questions.
On which you have to read much. You have to read. That is the only way that you have to do. You have to read more and more. See, that is why, I keep asking, especially the foundation, I keep dictating, or I keep sending PDFs, right? So suppose you find a very good article, right? Very good article. And that article relates to, different aspect of, suppose, secularism, the question was there, right? Now you take that article, and from that you take out few good lines. See, remember, you cannot write such a beautiful lines by yourself. Okay, you cannot simply write, because those people who are writing those articles, they have experience of 30-40 years, and there is like an old wine flowing from their pen. If you start that, no, I will write like this by myself, it is a futile exercise. In 2 years time you cannot write like that, right? So it is better to take that particular crux, right, and make a separate note that this is a topic in which these are the 3-4 generic philosophical lines that I will write if there's a question. Getting my point? Yes. Okay, so that way you can, for each topic make it one, and that will improve you.
Sir, do you suggest any source for these kind of articles, sir?
Multiple sources are there. The best source, I think, is this, corner state of the nation, Indian Constitution. Yeah, working of a democratic constitution. This Austin's book. This is a very good book.
Glanville Austin, yes.
Yeah, Glanville Austin book. But very perfect book. Right? So that can be used. Okay.
Yes. Thank you so much.
Chali, thank you. Yes, Akshara, go ahead. Yes, Akshara, go ahead. Yeah, I can hear you. Good evening.
Sir, I have 2 questions right now.
Yeah.
First, constitutional law, though those answers, those questions are very easy to attempt as they are philosophical, and I have a bit writing experience in magazines, sir. So I can attempt, but those questions are not fetching very good marks as compared to.
Yeah. Very correct. That is why, someone asked me, sir, what to, where you have to give 150 marks and where you have to give 100 marks, right? So I always suggest go for IL. Right? So even though constitutional law, paper seems to be very easy or very philosophical and very interesting to write as a, as a law graduate, you feel like you can write it much better. But it is very subjective. It depends upon the person who is checking the paper, whether he likes your answers or not.
Exactly,
right?
sir.
So that is why, better to err on this, international law side rather than going for the constitutional law side, right? It is very straightforward international law. There is no subjectivity involved. Very straightforward. Okay, these are the economic rights and duties of the state in exclusive economic zone. The 5 points, and that is universal. Nothing to add, nothing to subtract.
Exactly.
Okay, so it is much better approach.
Sir, I was watching your right now Zoom meeting. As I saw in the paper as well, constitutional law, those are easy. I can attempt it very well, but as compared to it's very those answers are like ready-made. You can make it and
simply write it down. Yeah, the best thing is test, right? You simply to take the test, or previous question, leave the test, previous question, and write the answer and take the feedback. Right, write the answer, take the feedback, and make a very, if you write define international terrorism 5 times, right? So no matter what question comes from international terrorism, you will write good answer.
Exactly, sir.
That's
So
the point.
has is related to current affairs. I've been going through that Law Teller magazine, and I note down only to the Supreme Court judgment. So that
Sufficient. Yeah. Law do not requires you to read each and every judgment. I have given that article also. I wrote. I gave you. I have given you the links of that particular judgment if you want to read in detail. But no need. Simply talk about this was judgment related to this. That's it. That is what actually needed to be cited. You cannot write in the fact of the case what the Supreme Court argued. No need. No need for that.
Thank you so much.
Okay. Thank you. Advocate Ajay. Yeah, very correct. International law. Priya is asking. Yes, Priya, I think I have answered your question, right? Philosophical type. So you can write in points. There is no doubt, and give proper headings. Heading is quite important. Okay. Yes. I prepared nearly each and every. Yes, Ashish. Then you write the paper and submit it to me. Okay? Write the paper, submit it in the PDF. Okay? Chili, so Bhavesh says I have taken his question. Akshara also I have taken. Yeah, Mithuni Devi, the last question. Mithuna Devi. Yes, please go ahead. My email ID, I have told you, Aditya Tiwari @outlook.com. No question from Mithuna Devi. Okay. So last question of Himanshu I will take, then we will take leave. Yes, Himanshu, go ahead.
Hello, sir.
Yes, can you hear me?
Sir. Yes, sir, I can.
Let Himanshu, you wait. First, let this Mithuna Devi speak, okay?
Okay, sir.
Okay. Yes.
Sir, what kind of advantage a law graduate can have than a political science students in the civil service main examination, sir?
Law graduate while writing law.
Yes, sir.
See,
and a student can get an advantage than the political science student when compared to law.
Okay, you are saying that if one political science graduate and law graduate both are writing law mains examinations, so
yes,
who will
sir.
have the advantage?
Yes, sir. Yes.
Yeah, see, in some of the topics, I think both will have same, but in some of the topics, law will have a little bit more advantage, like in the case of crime, right?
Yes, sir.
Because
yes,
in the case of constitutional law, I think political science student might write better answer, right? Because most of the time the questions are philosophical, right? International law also they are at equal footing, but in some of the aspects, the law graduates are really at an advantage. But that advantage can be part by political science student, right? The simple thing is that they will have to take 15-20 days of extra effort. That is what that will be needed.
When compared to law graduate?
Yeah.
That is, sir.
Yeah.
Yes, sir. Yeah. Whether the law graduate can have a depth understanding of the constitutional law when compared to political science students, sir?
Yeah, you can say that. You can say that.
Oh. So as a law graduate, you should have some kind of the applicability with respect to law.
Yeah, very correct.
When compared to political science students.
Yeah, that will be much better.
Okay, thank you, sir. Thank you. Very kind of
you. For which book should be international law? Yeah, multiple books. Yeah, people refer Kapoor, but I don't like Kapoor personally. I go for this. What is this? The Stark's International Law. That is very better book, and the PDF is freely available. You download it. Okay, Himanshu, last question.
Good
yes,
evening,
Himanshu,
sir.
please go ahead. Yeah.
सर मैं आपके लास्ट 2019 बैच से हूँ.
Okay.
तो सर जैसे आंसर राइटिंग की आदत काफी छूट गई है सर.
क्यों छूट गई है पहले तो आप ये बताइए, अभी तक कहाँ गायब थे आप?
तो सर वही है, सर फ्री की तैयारी में लग गए थे, तो फ्री निकला तो फिर फ्री में लगे रहे. तो सर उसके लिए फिर से सर ट्रैक पे आना चाहते हैं.
तुम ऐसा करो, किस बैच में तुम? फाउंडेशन में थे, टेस्ट सीरीज में थे, या किस में थे तुम?
सर लास्ट बैच लुकमान वाला जो था आपका.
अच्छा, मतलब फाउंडेशन वाला ना?
यस सर.
हाँ तो ठीक है, तो कोई बात नहीं. वो तो एक बार तुमने एडमिशन ले लिया, तो मैं तो जब तक पास नहीं करूंगा तब तक कॉपी चेक करता हूँ बच्चों का. ठीक है, तुम ऐसा करो, ये जो इस बार वाला जो 20 वाला पेपर आया है ना, ठीक है, ये तुम पेपर 1 और पेपर 2 दोनों लिखो और भेजो मुझे.
यस सर.
ये तो कर सकते हो ना?
हाँ,
जरूरी नहीं है कि भाई 2 ही दिन में भेजो. तुम एक हफ्ता लो, 5-5 क्वेश्चन करके लिखो तुम, ठीक ना? सारे क्वेश्चन लिखो. उसमें वो मत करो कि हाँ भाई मैं चूज कर रहा हूँ. हर एक क्वेश्चन को लिखो, क्योंकि प्रैक्टिस करना है ना. क्वेश्चन को लिखो, मुझे दो. एक बार ना हो तो 1-to-1 जूम मीटिंग कर लेंगे, उसमें मैं एडवाइस दे दूंगा कि भाई कहाँ लैग कर रहा है, क्या क्या चीज करना है. दैट आई विल हेल्प.
यस सर.
ठीक है ना? अब करना ऐसा नहीं कि मतलब आलसी बना के हाँ भाई हो जाएगा कर लेंगे, ऐसा नहीं होना चाहिए.
नहीं सर, नहीं सर, करेंगे.
तो ठीक है, तुम मुझे सबमिट करो. फिर एक हफ्ते में मुझे मेरा व्हाट्सएप नंबर होगा तुम्हारे पास, ठीक है? टेलीग्राम नंबर तुम सबमिट करो, फिर हम 1-to-1 ऑर्गेनाइज कर लेंगे. कोई दिक्कत नहीं.
हाँ, पहले हम लोग का व्हाट्सएप ग्रुप बना था एक, हम लोग का, आपको अगर याद होगा पहले तो.
हाँ नहीं, तो वो तो मैं हटा के टेलीग्राम पे ले गया ना, कि व्हाट्सएप पे बड़ा दिक्कत होती है ना वो.
हाँ यस सर.
100 लोगों की लिमिट है ना, 100 से ज्यादा हो नहीं सकता है. टेलीग्राम पे क्या है कि मल्टीपल आ सकता है, इसीलिए.
यस, ठीक है सर, लिखता हूँ.
हाँ, लिख के सबमिट करो.
थैंक यू सर.
ओके, थैंक यू. चले फिर तो वाइंड अप करें आज के लिए एवरीवन। यस फराह स्टार्क इंटरनेशनल लॉ। कल परसों प्लान करते हैं फिर पेपर 2 का डिस्कशन, ठीक है? फिर ऐसे ही करते हैं। पेपर बड़ा अच्छा था, देख के बड़ा अच्छा लगा, इसमें कोई डाउट नहीं, इट वाज वेरी नाइस। और कल वो फाउंडेशन वाली बैच है तो उसका पहले मैं इंट्रोडक्शन ले लेता हूँ, कल वाली क्लास में देखता हूँ ओपन टू ऑल कर देता हूँ मैं, ठीक है ना? ओके चले फिर, ओके वाइंड अप करते हैं, कल मिलते हैं फिर। ओके थैंक यू। यस अक्षर आई नो, अच्छा यू आर आल्सो फॉर फाउंडेशन, दैट्स गुड। चलिए कल मिलते हैं फिर, ओके बाय।